Myself, Manupriya Chalan, along with my co-anchor, Hananasa, will be the student moderators for this session, and we take the privilege to welcome each and everyone present here today.
Kerala Law Academy has proved its eminence in legal erudition by being in par with international standards. The Kerala Law Academy Law College, which since its establishment in 1966 has been a beacon of excellence in legal education, consultancy, and research. The Center for Advanced Legal Studies and Research is the research wing of the Academy. Small cheer and a great welcome makes a merry feast. Now, we have Dr. Dakshna Saraswati Ma'am, Associate Professor and General Secretary, Kerala Law Academy, Moot Court Society, to deliver the welcome address on this occasion. Ma'am, please.
Good morning, one and all. Honourable Surendran K. Pattel, State District Judge, Fort Bend, State of Texas. Advocate Nagaraj Narayan Sir, Director, Kerala Law Academy. Professor Anil Kumar K. Sir, Director, Administration, Students and Faculty Affairs. Professor Anil Kumar G. Sir, Vice Principal, Kerala Law Academy. Esteemed guests, faculty members, and dear students. It gives me immense pleasure to extend a warm and heartfelt welcome to all the legal dignitaries who have gathered here to take part in this think tank professional lecture series organized by Kerala Law Academy Law College in association with CULSR and IQAC KLA. As we commence this significant event, I am honored to introduce our honorable guest who has graced us with his esteemed presence, enriching our gathering with his invaluable insights and expertise. First, it's my privilege to extend a heartfelt welcome to the chief guest of the day, Honorable Mr. Surendran K. Pattel, State District Judge, Fort Bend, State of Texas, who is a distinguished legal luminary and a true embodiment of dedication and commitment. Sir was elected as a judge of the 240th District Court in Fort Bend County, Texas in November 2022. Sir's illustrious career spans over a quarter century practicing law both in India and the United States. Sir has made significant contributions to the field of family law, civil and commercial litigation, real estate, criminal defense, and transactional matters. His commitment to community affairs and democratic politics further highlights his dedication to public service. Sir is an active member of several prestigious associations, including the Fort Bend Country Bar Association, the Harris Country Bar Association, the Exchange Club of Sugarland, and the Malayali Association of Greater Houston. His journey from Kerala to serving as a judge in Texas is a testament to his hard work and dedication. Sir, we are deeply honored to have you with us today. Your presence and insights will undoubtedly enrich our gathering. We extend our warmest welcome to you, sir. We extend a sincere welcome to Professor Anil Kumar K. Sir, the Director of Administration, Students and Faculty Affairs at Kerala Law Academy. Sir has consistently provided unwavering support to every endeavor within our college, leaving his invaluable mark on every aspect of our academic and extracurricular activities. We welcome you, sir. Next, we extend a gracious welcome to Professor Anil Kumar Ji, sir, Vice Principal of Kerala Law Academy, Assistant Professor Kasturi Ma'am, Professor Dr. Ajita Nair L. To this function. We offer a sincere welcome to Dr. Malavika J. Ma'am, Assistant Professor, Kerala Law Academy, who will be delivering the vote of thanks to this event. Hearty welcome, ma'am. Next on our esteemed list, I am delighted to extend my warm welcome to Advocate Nagaraj Narayan Sir, Director, Kerala Law Academy, and Member, Bar Council of Kerala, the pillar of strength for our institution, who even in his absence today has extended his deepest support in shaping this event to a reality. Last but not the least, a heartfelt welcome to the teachers, IT team, and non-teaching staff, all those whose collective efforts have been indispensable in making this grand event run smoothly. Once again, I extend a warmly welcome to our distinguished guests, faculty members, and our dearest students. This gathering of dedicated individuals is a testament to the collaborative spirit that propels us forward. Thank you all for being a part of this extraordinary and informative journey, and let us look forward to an enriching experience ahead. Thank you.
Thank you, ma'am, for your warm welcome. I take this opportunity to welcome you as well, ma'am.
Today, we have the esteemed presence of the most distinguished guest of the day, Honorable Mr. Surendran K. Pattel, sir, State District Judge, Fort Bend, State of Texas. Sir's professional journey started back in 1996 in Kerala as a trial lawyer. He dealt with civil and criminal cases, election law, matrimonial proceedings, and labor and industrial law. Sir moved to Delhi in 2005 and started practicing law in the Supreme Court of India and eventually moved to the United States of America in 2007. In July 2015, he started a law firm in Texas named PKS Law Firm. As a lawyer, Sir has worked in affiliation with the Fort Bend Bar Association, Harris County Bar Association, State Bar College, and Exchange Club of Sugarland. He was summoned as a judge of 240th District Court in Texas, Fort Bend County on 1st of January 2023. It is an utmost honor to have you with us, sir, on this auspicious occasion. Now, I would like to request Professor K. Anil Kumar, sir, Director, Administration, Students and Faculty Affairs, Kerala Law Academy, to present a token of gratitude in the form of Punada to our most distinguished guest of the day, Honorable Mr. Surendran K. Pattel, sir. Sir, please.
I'm deeply privileged to now invite Honorable Mr. Surendran K. Pattel, sir, to enlighten us on the session, United States Judicial System, a comparative analysis. Sir, please.
Good morning. Before I start, I would like to recognize a couple of people who gave me this opportunity. Mr. Umar Sharafuddin from College Station, Texas, and Shant from Atlanta, Georgia. I know Umar for more than a year now, but I never met, but talked over phone a couple of times, Mr. Prashant. When they saw my interview a few weeks ago, that is when all the talk started, and then connected with Mr. Nagarajan, and immediately the turned to a very prestigious event in my life to talk in front of the students from the Law Academy Surendran. This institution produced a lot of eminent jurists and is going to continue, and we may be one among the jurists now maybe leading the Indian jurisprudence in future. So I'm happy and I'm glad and I feel that I'm blessed to be here today. One of my best friend, P. Dinesh, who elevated and designated as the senior lawyer in the Supreme Court of India a few months ago, was also a product of this institution. So that also gave me a pleasure and happiness to stand in front of him, just to talk to him yesterday, that I'm coming here to his college. And once again, thank you for having me here. Before I conclude my speech, I'm going to say a few words in Malayalam as a commitment. My daughter, she said that you should talk in Malayalam when you are in Kerala. So I practiced both in India as well as in the United States. So that is why I made this suggestion. It is better to have a comparative analysis of the two judicial systems. The first and foremost difference between the United States and the Indian legal system, what I think is the jury system. In the United States, most of the trials are conducted by the jury system, and in India, we have the bench trials. Other than that, I see surprising similarities than the differences between the two legal system. When I moved to United States in 2007, end of 2007, I didn't know what to do. I practiced from this is the only profession I want to do in my lifetime. So that is my passion. And I don't want to enter into any other profession. So I started my career in 1996 and we went up to the Supreme Court of India. Then all of a sudden it is down to zero. Uh, in that frustrating moment, I started continuing the research and seeing if there is any path forward for me. And I find that in Texas, there is a rule which allow commonly practicing attorneys who have a good standing, 7 years good standing in their country, can directly appear the bar exam, provided they should pass the bar exam in 2 years of their arrival in the United States. So this gave me a hope. By the time I find out this provision, it is almost an year, and then there are only 1 year left and 2 exams left. By the time they approve my application, there is only 1 exam left. And I would have to sit along with the US students who completed their courses, 4 year courses in the United States, and the passing rate for those students is usually 50 to 60%, the bar exam results. So it is kind of hard, but my experience as a trial and appellate lawyer here in India helped me a lot to pass the bar exam in the United States. The fundamental principles, I didn't see much differences at all. 2 weeks ago, I tried a case that was a bench trial, and when the attorneys are arguing the usement issues, I see many of the principles that I argued 20 years ago. So the fundamental similarities are too much. The similarities are more than the differences. When it comes to the trial itself, there are maybe some procedural differences. One of the fundamental difference I mentioned earlier is the jury selection process. As we see, all the trials here are the bench trial. Vast majority of the trials in the United States are the jury trial. Criminal cases, almost all of them are jury trials. In district courts, there will be 5 jurors, and the county court at law, the court below, is 6 jurors. And in criminal courts, all the jurors should decide unanimously. So the 12 jurors, if the 12 jurors are not agreeing on the result on the guilt or innocence, that is the first phase of the trial, then there is a mistrial and new trial should be ordered. That happens once in a while. And 2 weeks ago in my court, jurors are on one side and one juror is on the other side. The deliberation continues for 8 hours and there is no change. And there is a provision to called iron charge that giving a direction to the jurors that if you are not agreeing on the decision, you have to send it home, and another panel is going to be impaneled, and they have to face the same questions. So the task will be the same. The challenges of the question that you are facing would be the same that the new panel would be. So try to deliberate more. So that giving them an ultimatum that you should deliberate and come to a conclusion. But still, the one person doesn't want to change her mind. That is one of the beauty of the jury system, because you have the ultimate decision. You don't have to compromise your conscience. And we have to, in those circumstances, we have to order a new trial. But in the civil cases, 10 out of 12 needs to be agree on the results. And the reason why is that in civil cases the standard is the preponderance of the evidence, so the weight is which is more likely than not. But on the criminal case, the standard is beyond reasonable doubt. So you are dealing with the life of somebody. And unlike in India, here when I was practicing here, the life sentence means 12 years, and you can be get out from the jail maybe in 6 or 7 years. But in lifetime, in the United States means that it's almost literally lifetime, and you are not entitled for a trial until you completed at least half of the term, which may be almost full of his lifetime. So that is one of the difference and the consequences of the jury trial. I would like to explain a little bit of how the jury selection process is going on in United States. Um, Most of the trial that come to my court are, my court is the highest trial court. District court is the highest trial court. So all the felony cases like a capital murder, sexual assault, robbery, burglary, those are all the heinous crimes, and they are the one coming to my court. And the civil cases, 500,000 and above, so $1 million claims are coming to my court. 3 weeks ago, my associate judge conducted a civil trial, and the award was $5 million for an accident case. So those are all the cases coming to my court. One of the serious offense that we are facing, and a challenge we always face to get enough jurors, are the sexual assault cases, especially if it comes to the minor. If the victim is a minor, then we would find a lot of challenges to get enough jurors. So we would pool at least a 90 to 100 members of the panel. And out of this 100, we would barely make 12 jurors. How the process works is, from the general jury pool, we pool 80 to 90 people for that particular case to be decided. Then there is a procedure called voir dire, that is questioning the panel, the 90 people, to make sure that they are fair jurors for this particular facts and circumstances of the case. So both parties, the prosecution as well as the defense, are allowed maybe 30 to 45 minutes or 45 to 1 hour to ask questions to the jurors, specifically to identify whether this individual has any prejudices, biases, or one side or the other, or whether that person can be a fair juror in that particular facts and circumstances of the case. So once those questions are, it can be done by the judge solely without involving the attorneys, but most of the judges prefer give that opportunity to the attorneys, so that they can ask their question in order to make sure that we are getting the correct panel. The judges usually make some introductory remarks, identify the parties involved and what exactly the case, maybe the definition of the cases that involve the legal principles, and the definitions may be the introductory part, and then the rest of the question will be, so some of the questions may be, how many of you have an experiences in your life, or your friend's life, or your neighbor's life, or your family members, or the relatives life that has an experience, or a victim of a sexual assault. I'm giving that as an example, sexual assault as an example, because that is one of the cases coming up frequently in the trial side. So when we are asking, raise your card, the jury card, the hands that raise will be almost 90%. So almost everybody has some sort of experiences. Some of their family, friends, or neighbors, or relatives are affected by some sort of sexual assault. So then the question would be, does that feeling or experiences affect you in your deliberations or your determination of this particular facts of the case? How many of you can set aside your feelings and listen to the evidence presented in this case carefully and without moving with emotions? And carefully listens and set aside your feelings and decide the case based on only the evidence presented in this case. Still, there will be a lot of people saying that, no, I cannot decide those kinds of cases because it is too much emotion. And the experiences that I faced, my family faced, my neighbors faced, my friend faced, it is too much. So I cannot sit for this jurors. So that is the answer that we usually hear from a lot of people. Some people would definitely want to sit in this and to see the evidence, and also to. So that is one of the attorney is asking those questions, and that give them an opportunity to identify which person may be. The questions that they are facing would give them an indication that whether that particular person would be a fair juror or not. Once that is concluded, then the striking process starts. Most of the judges allow the parties to agree on the strike for cause. Strike for cause is that assume that one person said that no, if there is a person who is accused of a sexual assault, I'm 100% sure that he did that. Otherwise, what is the reason for filing a charge against him? So I'm convinced already, without even looking into the evidence, um, he did that. So that is a bias, right? So that juror definitely not a fair juror because that juror already decided. So there is no presumption of innocence in the mind of that particular. So that juror is not qualified. Sometimes the both the parties agree, yes, that person is not qualified, then they can remove that person as an agreed. Those are all the strikes for cause. There is no limit for striking a juror for cause. If we have 90%, all the 90 may be strike for cause if all of them are prejudiced or biased to one side or the other. Once that strike is in the strike for cause is completed, then the another strikes called preemptory strikes. So each sides in the district courts, especially in the criminal side, they will get a 10 strikes each side. They will get a strikes. They can strike anybody they want without any reason. It is their choices. So they can do that. Then we count the numbers, the remaining number of members available in the panel. Then the first 12 is going to be the jurors. Most often, we select one or two as an alternative jurors. They are not entitled to sit during the deliberations. There will be a separate place for them to. The reason why we are having a one or two alternatives is because if one of the permanent juror is unable to continue the proceedings, the leader wants to break the proceedings, so we can immediately fill the alternative juror. We always sit with the jurors, listening to the evidences, participating in the process, but in the deliberation, they will not, unless one of the original juror is excused. If one of the original juror is excused, the alternative is replaced immediately, and they will step up and continue the proceedings. So that is one of the striking feature of the jury selection process. In criminal cases, there are two phases as similar to the Indian judicial system. The first is the guilt and innocence phase, and the second is the punishment phase. So once the guilt and innocence phase is completed, the parties, the defense can choose whether they want to go to the jury for the punishment phase or to the judge for the punishment phase. But they need to make that election at least on the day of starting the trial. So if they decided to choose the judge, then for the punishment, then the jurors are excused immediately after the guilt and innocence phase. And if the jury find that the defendant is guilty, then the punishment phase goes to the judge. If they decided the jury, the second phase start immediately after the guilt and innocence phase. There will be a charge. For both the guilt and innocence phase as well as the punishment phase, there will be a jury charge. And the jury charge is an instruction, a set of instructions that the judge prepare and give to the jurors. That usually contains some instructions, the definition of the charge, the elements of the charge, what we are looking for the proof, what is the standard of proof, and how they meet. And then there are a couple of questions based on the evidence presented. Do you find this person is guilty or not? So those are all the questions. They only answer those questions. And in the punishment stage, then there is another charge, a written charge, and then they will decide how many years or whether they are entitled for probation or community supervision or things of that nature. So that is kind of jury instructions and the jury selection process. Any questions on that? Now? Yes. The charge will be required by the judge all the time. And that is kind of an instruction. This is what you need to do. Even though the jurors are the ultimate fact finders and the judge of the facts, they cannot deviate from the elements of the crimes, right? So they don't know. They are the laymen. They may not be they may not have any idea what exactly this particular crime means. So we give the definition, we give the elements of that particular crime, said one or two uh, paragraph as an elements of this particular crime. So then if they believed beyond reasonable doubt that the prosecution is proved this case beyond reasonable doubts of all elements of the crime, then they can find that this particular person is guilty of the offense charged under the indictment. So that is it is kind of, even though it is a jury charge, the judge and the attorneys have a lot of work to do in order to navigate the jurors to make a right decision. Any other questions? Oh, okay. Grand jury is an entirely different process and an institution itself. Grand jury is the one who is making a decision whether a particular person is to be charged or not. So it is an indictment. Here you are filing a complaint before the SHO, station house office, right? And they decide whether a charge needs to be filed or not. In grand jury proceedings, you file a complaint either before the police or before the sheriff department or before the district attorney. They all investigate into and make a determination whether this person needs to be charged or not. Then that paperwork needs to be presented to the grand jury. The grand jury is 16 people. And that grand jury, they present all the evidence before the grand jury. Usually the defense cannot present before the grand jury, only the prosecution can present. So sometimes the defense attorney, if they hired already, they can present some mitigating facts and say, to convince the jury. It is not a adversary proceedings at that moment, because the prosecution may not be available during the defense presenting their case, or during the defense may not be. They are not at all eligible to participate when the prosecution convinced in their case before the grand jury. It is the preliminary stage of the case. And once they heard all the evidence and all the information, that is the better the term to be used, because we are still in the preliminary stage of the proceedings. So the prosecution presenting all the information that they believe is enough to indict that person or to file a charge against this person. They're presenting all this information to the grand jury, and the grand jury evaluating and and then they'll make the decision whether that needs to be that person needs to be indicted or not. Once they decided, then no, this is not a case that we need to be moved forward or prosecuted. This is just kind of a brush aside kind of thing. Then they will file a noble. Noble means that no charge. He is free to go instantly. There is no charge at all. But once they decide the charge is to be filed, then that indictment goes to the judge, one of the district judge. In Surendran County, we have 8 district courts. Out of the 8 district courts, 5 district courts are routinely supervising this grand jury proceedings for 6 months period. For that particular 6 months of period, all the indictment goes to that particular judge for signature, and once he signed, then that person is charged for the offense alleged. That is just the beginning of the proceedings. Then it is going to a particular court. Then he maybe get arrested, and then he can post the bond. He can get out by bail, and then all the discovery proceedings starts. The prosecution needs to provide all the discovery to the defense. If there is any evidence that the prosecution know about the defendant or relating to that case, all of those information needs to be given to the defense attorney regardless. And if there is any exculpatory evidence that the prosecution came to know even on the day of the trial, they need to disclose that to the defense. So all the information that benefits the defense should be disclosed to the defense, so they can prepare for a better trial. I think that is not available here. The prosecution may not reveal all the evidence to the defense attorney. Here, the defense attorney trying to find their own way. In the United States, you don't have to do that because they are liable to provide all the information they have. Sometimes it may be millions of pages of documents. I remember one of the murder trial I conducted. A week prior to the trial, the defense attorneys asked for some documents relating to the witnesses that the prosecutions are planning to present. And the defense believed that some of the officers had some prior criminal history. So they want all the information. And the prosecution vehemently opposed. Then they both agreed that the judge can do an in-camera inspection of those documents and can decide whether that needs to be released or not. So they gave me 7,000 pages of documents, and I had to review over 7,000 documents in 2 days. And since they thought that it is almost impossible, they asked for a continuance, and I said no continuance. I will review all the 7,000 in 2 weeks, and I did that, and I released some of the documents to the defense. So what that means is that the defense is eligible for getting all the information that may benefit for their defense. That is in terms of the evidentiary. One other thing about of the criminal proceedings that the motion in limine. Motion in limine means that prior to the starting of the trial, both sides may try to narrow down the scope of the trial. For the prosecution, they said that such and such a question should not be asked during the trial. It may mislead the jurors. So before asking those questions, we need to approach the judge for the permission. The defense may also ask those questions. One of the most prevalent concept is that no extraneous acts or commission or bad acts of the defense shall not be introduced during the guilt and innocence phase of the trial. So, for example, if a person is charged with a murder and he had a prior history of a robbery or another murder, that prior act shall not be introduced in evidence during this trial because the jurors are not looking into what exactly happened in this case. They are looking into the prior acts and making a decision that, oh, this guy already did that. That means he definitely did this too. So the jurors are not supposed to make a decision based on any of the prior acts of they are only looking into the evidence presented by the prosecution in this particular facts and the circumstances of the case, whether the prosecution proved all of the elements of the crime alleged in this indictment beyond a reasonable doubt. But there is one crucial exception to that. In a sexual assault case, if a minor is involved, then none of these rules are applied. The prosecution can introduce the prior sexual behavior of the defendant. And hearsay exception is also hearsay rule is also not applicable in a sexual assault case where the minor is involved. For example, a minor may not be able to testify, and if the minor disclosed the sexual assault to an adult, maybe even a delayed outcry, the disclosure is called outcry. Even if it is a delayed disclosure or a delayed outcry, that doesn't matter. And that adult, when that adult is testifying, that is hearsay, right? Somebody told her or somebody told him that this has happened, so it is a hearsay. But if that incident is that disclosure is relating to a sexual assault of a minor, then the hearsay rule is not applied. The court can admit the evidence presented by that particular person, and the court can allow that person to testify, even if it is a hearsay in the general principles of the rule. that is one of the cardinal feature of the United States law regarding the offense against the minors. There are a lot of protections available to protect the interest of the minors in those circumstances. Any questions? When it comes to the civil trial, the trial is almost the same. But as I said earlier, the jurors doesn't have to be unanimous. If 10 or 11 jurors can agree, and then that is the decision of the jurors. Sometimes there is only one phase. Sometimes there might be a second phase. For example, the jurors are eligible to decide only the factual aspects of the case. If there is only a question of law, then the jurors cannot decide that case, that aspect of the case. And then that needs to be decided by the judge. So then there can be a bifurcation to decide the facts and the law. For example, one of the issue only the judge can do maybe an exemplary damages, an equitable relief, a declaratory judgment, things of that nature. In that case, the trial is to be bifurcated and the legal issues needs to be determined by the judge and the facts is to be by the judge. If the judge is trying the case, after the judgment is passed, then the parties can ask for the findings of facts and conclusions of the law. In addition to the judgment, the judge also needs to write findings of fact and conclusions of law. So most of the judges prefer the jury trial because once the jury is rendered a verdict, then the judge needs to sign only the judgment. And the findings of fact and conclusions of law needs to be applied in the jury trial, jury verdict cases, in the civil cases. I tried a couple of bench trial, which was much interesting than the jury trial. One recent case was a case involves the city elected officials where they decided that one of the city council member is ineligible to continue as an officer because they automatically vacated the office by changing the residency to a new city. So the question was who decide what is there is no enforcement procedure in the law. There is no enforcement provision in the law. So the city administrators decided that that particular seat is vacant. They immediately filed a lawsuit. And we did that a fast track trial. The suit was filed in February of 2004, and we concluded the trial in 2024. So it is kind of three months. We completed the trial, and it was a bench trial because there is not much factual findings need to be rendered. Most of the questions are legal questions. So one of the question was whether even though it is automatically vacated, the provision says that if the elected city council member change their residency from that city to a different city, then they are automatically vacated. The city is automatically vacated. But who will decide that? Since there is no enforcement proceedings, the argument of the plaintiff is that they should come to the court and make a declaration that the seat is vacated. They have to prove that there is actually. So the definition was kind of the intent of the party is the key in determining those kinds of cases. A temporary change of residence even will not qualify as a change of residence. So if the person now moving from Trivandrum to Calicut and still holding the Trivandrum Corporation Council member, staying there for a year with an intent to come back after a year to Trivandrum, then they haven't changed their residence. They are still the resident of the Trivandrum corporation. So that is kind of a definition. So I have to follow the rule, and I said that there was no changes residency. She can still continue as an elected office until the end of her term. So it is one of the case that came to my mind when I'm talking about the legal aspect. Any questions? Yeah. So the hierarchy of the judicial system, that is one of the another fundamental difference between the Indian. Thank you for that question. I almost forgot. I wanted to emphasize that one of the fundamental difference between the Indian and US judicial system is the hierarchy. Here we have on the top the Supreme Court of India, the High Courts of States, and the district courts, and the lower courts, right? In the United States, we have two parallel judicial system, one on the federal side and another on the state side. On the federal side, we have the United States Supreme Court and the circuit courts, which is the Court of Appeal, and then the district courts, that is the lower courts, the lowest court on the federal system. There are only three layers of the courts on the federal level. On the state level, it may vary from state to state, and that is another difference or a beauty of the American system. All the states have their own constitution, they have their own procedure, they have their own law, and they have their own systems of judicial system. In Texas, where I preside as a district judge, on the top we have Texas Supreme Court, and below that there are I would take a step back and say it differently. On the top, on the civil side, we have a state Supreme Court. On the criminal side, the top, there is a parallel similar proceedings on the judicial system, which is the Court of Criminal Appeals. The Court of Criminal Appeal is the one who decides the criminal cases on the state side level. That is the highest Court of Appeal on the states. And above that is the United States Supreme Court. So the state Supreme Court, Court of Criminal Appeal, and below that is the Court of Appeals. And then the district courts, then the county court at law, and the bottom layer is the justice of the peace. County court at law, as well as the district courts, their jurisdiction is the geographical jurisdiction is the county. And just as the peace, most of the counties are divided, subsequently divided, again divided in the form of 5 precincts, and the justice of the pieces are representing 1 precinct. So there will be multiple justice of the pieces. They are also called as mock claims court. And in addition to that, there will be some municipal courts appointed by the city councils, the mayor or the city council. They are just dealing with some of the very minor traffic offenses and things of that nature. They are appointed by the municipal councils. All other courts, judges of the peace, county court at law, the district courts, Court of Appeal, Court of Criminal Appeal, as well as the Supreme Court of Texas, all those judges and justices are appointed by or elected by the people during the general election. So now we have an election coming up in 2024, the presidential election, right? On the top of the ticket is going to be the president. Then if any of the state have a state senator is running, then the state senator, then the statewide offices like a governor, state representatives, Supreme Court justices, or district courts, Court of Appeal, county court at law, sheriff, or any other tax assessor, collector, district attorney, district clerks. All these are all elected officers. They are all coming in one ballot. So you voting for the president, then coming to the bottom, the precinct level constable or the justice of the pieces. So sometimes in bigger counties, there might be hundreds of candidates. So that is why most of the time there won't be much attention to the judicial elections. Most people listen who is running for what. So it is kind of an automatic party election. People would just vote for their party on the top of the ticket and coming to the bottom, and they just looking into the exemption would be a person like me, because this is a name that we usually don't hear or see, right? It is not an American name, so they may either wants to skip or not vote for those persons, but there is an exception too. That is why I came to the office. In the election 2022, the Indian voting population in that particular county would be the total population would be less than 7%. I ran for office on the Democratic Party side. And the Democratic Party voting bloc, I would say the Indian American voting population would be 10%. On the Democratic side, the total, when we are looking into the total, the vast majority of the Democratic voters are 65 to 70% are African American voters, and then Hispanics, white and Asian American, the 30% or 30 to 35%. The candidate that I was running against the sitting judge in the Democratic primary. So the incumbent at the time was a Democratic judge, and I ran against him for the nomination for the party. And it was kind of a 10% versus 70% was the battle. And fortunately, I won the race by 65% of the total votes. Then I did that African American in the primary, and then in the general election, I was running against a white Republican. And when we are looking at the general election perspective, the white population in that county is approximately 37 to 40%. African American is 24, Hispanic 24, Asian maybe 21, Indian American is almost 7%. So the 37% versus the 7% was the real battle. And fortunately, because of the hard work of my team, as well as the overwhelming support by the Malayali communities and the all Indian communities, I remember that half of the sitting judges in the Democratic side lost in that election. It was a wave against the Democratic Party on that during that term. Half of the sitting judges lost, and I was a newcomer. And because of that, we were aware that we are losing. So I made some phone calls to my other couple of community leaders and all the Indian community leaders, and saying that we need another 1,000 votes to win. And on the election day, they all made phone calls and make sure that regardless of the party line, they all came out and voted, and we won and made history and became one of the first district judge in United States of America. And I'm prouder than before because I made a commitment while getting elected that if I get elected as a district judge of this particular court, I will reduce the backlog in my first term, which is 4 years. By the end of the first year of the first term, the term is for 4 years. By the end of the first year of my first term, I reduced the criminal backlog into 50%. We have 540 district courts in Texas, and in 2023, I had the highest number of jury trial in Surendran County, as well as in the state of Texas, which is a record. It is not only a record in 2023. The first district court in Surendran County was established in 1976. We were looking into the record of the trial from 1976 to 2003. I tried the highest number of cases ever since the inception of the first district court in Surendran County. So I'm trying to fulfill by the commitment that I made to the people of the Surendran County, and making a difference in the life, trying to make a difference in the life of my constituents. Any questions? I'm more than happy to answer some other questions. It is not the question of how they will come. It is, I think, how far we want to go. when I decided to run for the election, one of the challenges I faced was I talked to the party leaders and I said that I would like to run for the office as a party leader. Leaders, what is your opinion? And they said, please don't run. Your name is the problem. That is true in certain aspects. Then I was kind of thinking that the Democratic Party is considered as the most diverse, the party that accepts people from all walks of life. So if the name is the problem, and then how can we claim that we are representing all the population, all the diverse group? Then my response was, if that is the case, let the people decide. And the result proved that they are wrong. So it is the question of how much you can work hard, how much criticism you can. You already know that while hearing that how maybe some of you will think that how this guy became a judge in the United States of America, his accent, the way he talks, it doesn't seem like it doesn't reflect the American way of talking, right? So that is exactly the criticism I faced. My opponent in the general election, he said that this guy doesn't even know how to talk in English. And my fellow workers were upset. They called me and they said that how we need to respond. And said, don't respond to him. You just campaign, talk to the people, ask their vote. But I immediately called all the media and I asked for their interview for 2 minutes. And all the media gave me 2 minutes interview. And I asked them, Surendran County is the most diverse county in the United States of America. So if a candidate, a judicial candidate who cannot tolerate the accent of his opponent, how can he become a good judge? That is my question. And I told the people that he is not talking about me. He is talking about us. Go vote. And they went vote and we won. So one of the thing I would say is that in America, the judges are mostly reluctant to go beyond the scope of the judicial function as such. You don't see too much judicial activism in the United States system. Here we can see that I think the basic structure of the Constitution. It was not that was a concept introduced by the judges, right? In one of the case when they decide the fundamental rights, they introduce the new concept that this is even though this is not there in the fundamental rights, this is the basic structure of our constitution. So the state cannot do this, the government cannot do this. I'm not saying that is wrong, but that is kind of an invention by the judicial branch. So those kinds of invention you cannot see in the American judicial system. They try not to interfere. They try not to answer some of those questions. Sometimes they may say that, oh, that particular question, we already decide the disputes involved in this particular issue, so we are not going to answer that question. When the appropriate time comes, we will answer that one, and that appropriate times may not come at all, because there are ways to avoid answering some questions, right? So they usually try to avoid. In one sense, it is kind of a respecting the other branches of the government. They don't want to interfere too much. We already see the encroachment by the executive branch to the legislature. For example, in the Constitution it says that all the international conflicts, if there is a war, and then it has to be approved by the Congress, and lot of international decisions when the president making some decisions that need the approval of the Congress. Over time, those are changed. There are some of some of the powers assumed by the uh, president by taking advantage of the situations, like when there is a war, the Congress gives some additional power to take control of the situations, or to make management to the emergency situations. So those emergency management control system eventually become an usurpation of the power of another branch. Most of the time, the judiciary try to avoid those kinds of encroachment to the other branches. Any questions? Okay. Uh, is that still on the live? Okay, so I had a funny answer, but I don't know that. But, that's not a choice. Basically, I will be honest. I started my practice. I was not even thinking about going to the United States. Um, I married, and my wife got a placement in Delhi. My practice before the Supreme Court was not a choice that I made on purpose. I was successfully practicing in the trial and first appellate side in Kasargod, in Hosturga and Kasargod. Even though money it was not that you know uh, good. My practice was very, very good. I was practicing before lower court Pukutu, and after 1 year of joining his office, all the trial, I got an unparalleled freedom of trying any cases, handling any files in that office. So that freedom, I exploited that freedom, I took advantage of that, and I tried almost every single case in that office. But in 2004, when I got married, after a few months, my wife got a placement in one of the prestigious hospital in Delhi, and eventually I had to move because during her pregnancy it became complicated. We don't have any family there, so I had to move, and I left behind my practice. I went to Delhi. And fortunately, I got an opening there, and I started practicing the Supreme Court of India, and I was able to argue 22 cases in a short period of time. Uh, and then I've got a placement in the United States, and I had to follow. And it was kind of a frustrating situation in one sense. At one side, there is it is a family, right? So we all separates our family. We want the family to be united, and you may guess you may sacrifice for the family. When I reached our original thought process was to settle her there, and I come back and forth to Delhi and continue my practice before Supreme Court of India. But on the moment we reached in the United States, we realized that that is not practical. Then, my older daughter was 1.5 years at the time, and my wife was pregnant for the second one. She is here right now. And we had a lot of struggles and difficulties, and we ended up in working with a caller. There is a grocery store in the United States. That is when we found this opportunity to sit for the bar exam, and I took that opportunity. So it is not a choice that I made to serve the United States and to leave India. That was not done on purpose. I was not leaving India to serve the United States. I left India to support my family, and then I find an opportunity there, and I thought that that is also a country that I can better serve. Then, realistically speaking, there is another aspect too. We need to think about that. If I was here, I don't know if I ever get elected in any public office. in any public office. That may not be the case. When the party leaders in the United States told me that please don't run, your name is the problem, please don't run, you may not win the case. I told them that I decided to run for the party that they are leading. And I beat the incumbent in that election and become the nominee and those party leaders supporting me in the general election. You cannot make those kinds of individual decisions in our system, right? It is not, you cannot as a person decide that, there is a difference in our system. I am not criticizing the system that exists in here. There is a difference. An individual cannot decide to run for, maybe you can if you are independent, but not as a, in the United States, even the primary, it is not the party deciding the candidate, it is the people. There is a twist at the primary election also, the general public is the one, entire voters are eligible to cast their vote in the primary election to choose the candidate for a particular party. So the people choose their party nominee and the people choose their ultimate elector office. I think I clear that answer clears the questions. I'm more than happy to answer the questions if we have time, or individually I will be available for a few more minutes.
Thank you so much, sir, for enlightening us with your words of wisdom and for patiently addressing all the possible queries. We are extremely honored to have you here with us today, sir. Thank you so much. Gratitude is the fairest blossom which springs from the soul. With that, I would like to invite Dr. Malavika J. Ma'am, Assistant Professor, Kerala Law Academy, to deliver the vote of thanks for this event. Ma'am, please.
Esteemed guest, Honorable Mr. Surendran K. Pattel, State District Judge, Fort Bend, State of Texas, Advocate Nagaraj Narayanan, Director, Kerala Law Academy, Professor Anil Kumar K., Director, Administration, Student and Faculty Affairs. So as we draw the curtains on this enriching session on the Think Tank Professional Series, hosted by Kerala Law Academy Law College in association with Culsar and IQAC KLA, I find myself deeply moved by a sense of gratitude and administration to consider it as an absolute privilege to present the vote of thanks to all those who have gathered here to be part of this event. Now, to fulfill the duty bestowed upon me, first and foremost, I would like to extend our deepest gratitude to Honorable Surendran K. Pattel, a very down-to-earth person, for his illuminating presence today at our event and his profound insights. Sir's journey, marked by exemplary achievements and tireless dedication, serve as a testament to his remarkable leadership and expertise in academia, entrepreneurship, and research. His exceptional contributions have not only enriched the field, but also inspired countless individuals around the globe. Sir, we are immensely grateful for the time and effort you have dedicated in sharing your knowledge with us and comparing the judiciary of both India and US extensively and exploring the more of a practical side. And thank you, sir, for being the guiding light for all of us in the field of education and beyond. Thank you for being a part of this event. We are definitely sure your words have left a lasting impression on all of us, and we deeply appreciate your commitment to justice and excellence. Thank you, sir. I also extend our profound gratitude to Dr. Dakshina Saraswati Ma'am, Associate Professor and General Secretary, Moot Court Society, KLA, whose tireless effort and steadfast commitment are a testament to her passion for excellence. In acknowledging her pivotal role, we extend not only our heartfelt gratitude, but also our deepest admiration in the immeasurable value she brings to our institution. Thank you, ma'am. We are truly indebted to Advocate Nagaraj Narayanan, sir. Though he is not physically present here, his constant support has been the cornerstone of all the activities in this college. He has been a guiding light for all of us, providing valuable insights and ensuring that the college remains a hub of excellence and innovation. I propose a sincere thank you to Sir, and I also thank Kasturi ma'am for his beloved wife for her presence. I would also like to acknowledge Professor K. Anilkumar sir, whose astute guidance and support have fostered an environment conducive to growth, innovation, and scholarly discourse. Today, as we reflect on the success of this event, we extend our deepest gratitude to Sir for his sincere dedication to the welfare of our institution and his commitment to the success of our academic endeavors. I express my deepest appreciation and gratitude to you, sir. I also extend my heartfelt thanks to Professor Harindran K. Sir, Principal Kerala Law Academy, Professor G. Anil Kumar Sir, Vice Principal Kerala Law Academy, and Professor Dr. Ajita Nair L. Ma'am, Professor and Senior Faculty Kerala Law Academy, who are the indispensable lot, who incredibly dedication to this cause of this college is always appreciated in one way or the other. Last but not the least, I would like to acknowledge the presence of our faculty members, students, the entire teaching and non-teaching staffs, IT and technical team, whose efforts behind the scenes have ensured the seamless execution of this momentous occasion. In conclusion, it is your collective support, dedication, and participation that have made this event a memorable and enlightening experience for all. Once again, I heartfelt thank you to everyone involved. Thank you and have a nice day ahead.
Thank you, ma'am, for expressing your heartfelt gratitude. With that, we have come to the end of this session. On behalf of our institution, I would like to thank all the dignitaries for joining us and enlightening us with their valuable words.
I also would like to extend my deepest gratitude to each and everybody who has worked for the success of this event, because nothing would be possible without a wholehearted support and guidance of such strong-willed and determined people behind the curtain. I also express my deepest gratitude towards Advocate Nagaraj Narayan Sir, Director, Kerala Law Academy, and Professor Anil Kumar K. Sir, Director, Administration, Students and Faculty Affairs, for providing us with such a great platform. I hope all the participants were able to relish each moment of this event to the fullest. Last, but definitely not the least, I thank each one of you present here for your kind cooperation. Thank you, everyone. Have a great day ahead. This is Manpriya Chillan, along with my co-anchor, Hannah Nasa, signing off. Thank you. All are requested to kindly stay back for the photo session. Please, thank you.